Second, legal capacity. Legal capacity is like the entry ticket to the contract party. Both the offeror and offeree need to have it, or they're not getting in. It's that simple. Without legal capacity, you might as well be trying to sign a contract with your pet goldfish. It's just not going to hold up in court. Now, who's got this magical legal capacity? Well, we've got two main types of contracting parties. First, we've got our legal entities, your corporations, partnerships, and the like. Think of them as the VIPs of the contract world. Then we've got individual persons, that's you and me. Here's the general rule: if you've got legal capacity, contracts are enforceable against you. It's like being an adult. With great power comes great responsibility, and in this case, that responsibility is being held to your contractual obligations. But as with any good rule, we've got some exceptions. Some people are deemed by law as incapable of contracting. It's like they've been given a get-out-of-contract-free card. Others might have limited capacity to contract. They can play the game, but with some restrictions. Speaking of limited capacity, let's talk about those contracts for a second. They're like a house of cards. They might stand, but they're easily knocked down. The individual with limited capacity can go to court and say, "Hey, I didn't really know what I was doing," and potentially void the whole thing. Now, for all you budding real estate professionals out there, listen up. It's your responsibility to be able to determine if the offeror and offeree have legal capacity to form a contract. You're like the bouncer at the contract club. You need to know who to let in and who to keep out. Why is all this so important? Well, lack of capacity can render a contract unenforceable or voidable. It's like building a house on sand. It might look good for a while, but it's not going to stand up to scrutiny. Understanding capacity is crucial for ensuring valid and binding contracts. Let's break it down with some examples, shall we? We've got a whole cast of characters in the world of contract capacity. First up, we've got the mentally incompetent. Their capacity is limited or non-existent, and they may be able to void contracts. It's like they've been given a do-over button for contracts. Then we've got our intoxicated persons. Their contracts are voidable. It matters whether the other party knew they were 3 sheets to the wind. It's like trying to make a deal with someone at last call. Probably not the best idea. We've also got our non est factum cases. That's fancy Latin for, "it is not my deed." These are voidable too, and it all comes down to whether the person understood what they were signing. It's like signing a contract in a language you don't speak. Not a great plan. Minors, those under 18, have limited or voidable capacity. But here's an interesting twist: they can enforce contracts that benefit them. It's like they've got a heads I win, tails you lose situation going on. On the other hand, we've got our corporations, partnerships, condominiums, and co-ops. They've all got capacity to contract, but with some caveats. Corporations are subject to their articles and bylaws. It's like they've got their own rulebook. Partnerships are interesting because any partner can bind the others. It's a one for all for one kind of deal. Condos and co-ops can contract within the scope of their regulations. They've got their lanes, and they need to stay in them. Finally, we've got our nonprofits. Their capacity to contract potentially depends on the organization's rules. It's like they're playing by house rules. You've got to know what game you're getting into. So the legal acts of minors that we just described are voidable, and what does that mean? These are the drama queens of the contract world. They start out valid, but they've got a skeleton in the closet that could bring them down. A voidable contract is like that friend who's great to hang out with, but you know they've got a secret that could blow up the friendship at any moment. Let's say you're 17, and you sign a contract to buy a house. That contract is voidable because you're a minor. Once you turn 18, you could decide to keep the house and honor the contract because its price went up, or you could say, "Nah, I've changed my mind," and void the contract. The ball's in your court. Another example of a voidable contract would be if someone held a gun to your head and made you sign a contract. That's what we call duress in the legal world. You could potentially void the contract later because you didn't enter into it of your own free will. And start with void contracts. These are the bad boys of the contract world. They're like that party you threw in high school when your parents were out of town. It never officially happened. Void contracts are unenforceable from the moment they're created. They're considered to have never legally existed, and no matter how much the parties might want to fix them, they're beyond repair. Imagine this scenario: you and your buddy decide to start a business selling, let's say, illegal fireworks. You draw up a contract and everything. Guess what? That contract is void from the get-go. It doesn't matter how fancy your signatures look or how official that paper feels, it's worth about as much as monopoly money in the real world. Another example of a void contract would be if you somehow managed to get your pet goldfish to sign a contract. I don't care how smart Bubbles is, that contract isn't worth the paper it's written on. Why? Because Bubbles lacks the capacity to enter into a contract. The same goes for contracts signed by people who are incapacitated, whether due to mental illness or, let's say, having one too many at the local pub. Moving on to valid contracts. These are the golden children of the contract world. They've got all their ducks in a row: offer, acceptance, consideration, capacity, and legality. They're like that straight-A student who also happens to be the star quarterback and volunteers at the local animal shelter in their spare time. Everyone loves a valid contract. Now, unenforceable contracts. These are the contracts that look good on paper, but for some reason, the court's not buying it. It's like having a really cool car that won't start, looks great in the driveway, but it's not getting you anywhere. For instance, let's say you make a bet with your friend that if it rains tomorrow, they owe you $1,000. You shake on it, write it down, sign it, the works. But when you try to collect your winnings in court, the judge is likely to say, "Nice try, but we don't enforce gambling contracts." It's a valid agreement between you and your friend, but the court's not touching it with a 10-foot pole. Finally, we have invalid contracts. This is a catch-all term that includes both void and voidable contracts. It's like saying bad contracts. It covers all the bases of contracts that, for one reason or another, don't pass legal muster. So, what's the big takeaway here? Well, void contracts are dead in the water from the start. They're like trying to drive a car with no engine. It's just not happening. Voidable contracts, on the other hand, are like a car with a serious mechanical issue. It might run for now, but one of the parties can decide to take it off the road at any time. Valid contracts are your reliable, everyday vehicles. They'll get you where you need to go, no problem. Unenforceable contracts are like having a car in a country where you're not allowed to drive. It might be a perfectly good car, but it's not going to do you much good. Remember, in the world of contracts, knowledge is power. The more you understand about these different types of contracts, the less likely you are to end up signing something you'll regret. Non est voidum. This little Latin phrase packs a big punch in the world of contract law. Let's start with the basics. Non est factum is Latin for "it is not my deed." It's like saying, "Hey, that's not my signature on that cocktail napkin." But in legal terms, it's a bit more serious than that. Imagine this scenario: your sweet old grandma, who can barely see the nose on her face, is tricked into signing what she thinks is a birthday card for her great-grandchild. But surprise, it turns out to be a contract selling her house for a measly $10. That, my friends, is where non est factum comes riding in on its white horse. This defense is used when someone signs a document but fundamentally misunderstands its nature or character. It's like going to a restaurant, thinking you're signing for the bill, but actually signing up to work there for the next 5 years. Now, before you all start thinking this is a get-out-of-contract-free card, let me tell you, it's not that simple. There are some conditions that need to be met. First, the person signing must have made a fundamental mistake about what the contract actually is. We're not talking about not reading the fine print here. We're talking about thinking you're signing up for a gym membership when you're actually agreeing to sell your kidney. Second, this mistake must have been induced by the other party's misrepresentation. In other words, someone must have pulled the wool over your eyes. If you just didn't bother to read what you were signing, that's on you. So far, we've covered 2 things. Next is consideration in contracts.